Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This video is for the Law of Tort students. Friends, in the class we discussed the topic nuisance, and for your review I am making this video. You all know that nuisance can be filed as a tort, can be filed as a civil case under section 93 of the CPC, and can be filed as a criminal case right from section 268 of the Indian Penal Code to 294A. You can file in any manner, but since we are dealing with the law of torts, let us confine to the tort cases. So please remember, nuisance according to Pollack, nuisance is the wrong done to a man by unlawfully disturbing him in the enjoyment of his proper right to property, or the exercise of common right, that is use of the common pathway or things like that. Anyway, this is actually French term that is Nure, N-U-R-E, which means to hurt or to annoy. Annoyance is the most important part of the nuisance. So the Latin meaning is no care. So what is annoyance? This first you have to know, because normally because of this thing we got annoyed, and this is nuisance, like that we will say. Annoyance is nothing but exasperation or vexation or state of initiation, then anger lastly. Please remember, కోపం వస్తే, దానివల్ల చిరాకు వస్తే, ఇరిటేషన్ వస్తే, this is all annoyance, and annoyance will result in so-called nuisance. Please remember, the result of annoyance will be hurt, danger, inconvenience to the enjoyment of life and property also. Right? So, what are the essentials of nuisance? To compose what are the nuisance, please remember, it is definitely there should be unlawful interference as defined by Mr. Pollack. So, as regards the use of some land or right over the property or things like that. Sometimes it may not affect the person directly, but it affects indirect manner. The nuisance can be created by intangible objects like vibrations, then smell, noise, gas, smoke, etc. Now we will go to the examples of nuisance, because every day we will be coming across these nuisances. High volume of radio or TV in your neighbor's house disturbing you. You want to have a peaceful sleep in the night after 10 p.m. But when the other people, they want to celebrate, if they raise the volume of their TV or their DJ or something, so it is very, very difficult. It creates nuisance. Friends, remember, a man of ordinary prudence, or a general man can hear, or our hearing system, ears can hear up to 140 decibels of sound. If more than that, definitely it causes annoyance to us. If the volume is more than that 140 decibels, definitely it creates nuisance. Then, branches of the trees protecting to others' property. So normally you raise a tree, vriksho rakshati rakshadha, definitely you can raise the tree. But when it falls or when it hangs over the other's property and creates, suppose if it sheds so many leaves, so they have to clean the same. It drops so many flowers and fruits also. If the fruits are useful for us, definitely we'll be happy. But since if they are not useful, definitely it causes annoyance to you. Then gases, injurious gases of factory spreading in the, so it is nothing but pollution. You may be knowing, suppose a person coming from Kandukur to Vangal, if he gets a beautiful smell, scented smell, then you can understand that you are crossing peril beverages. Actually, now I am in Rajahmundry. So, if the early morning around 3 or 4 o'clock, when I come out for a morning walk, definitely, if there is a noxious gaseous spelling, it is the release from the Andhra paper mills, Rajahmundry. Right? So, this is what is called air pollution. Right? So, two types of pollution are there. Number one, public nuisance, and second one is private nuisance. Public nuisance. Normally, so public means if General public, so it is a common law offense. Previously, we all come from the emanating from the precedents of common law only. Tort is not a codified law. Already I tell you, మనకు వచ్చే జడ్జ్మెంట్స్ అన్ని కామన్ లా నుంచి వచ్చినాయి. So it is a class of common law in which the loss or damage or the injury was suffered by the community as a whole. General public as a whole, community as a whole, not one or two families. When it is suffered by a community as a whole rather than by individuals, it is called public nuisance. Now we'll go to the public nuisance. Please remember, what is an offense? Already discussed you. What is a nuisance? Also same thing. If anybody does any act which is not warranted by law, if anybody does any act, అంటే కోర్ట్ చట్టము చెప్పని పని చేస్తే, ఆర్ ఇఫ్ యూ omits to discharge a legal duty, suppose early morning you wanted to keep your waste, తడి చెత్త పొడి చెత్త పెట్టాలి, తీసుకెళ్ళి మురుకాల్లో పడేస్తే, this is omission, right? So both omission and commission, they come under public nuisance. So examples I am going to tell you. So every day you will be coming across these examples. Digging a trench on the public path as though it is our right. Second, storing of stones, sand, etc. for construction of houses. Every day you will be seeing in the street. Third one, constructing structures on the public path. Then pouring polluted gases or liquids in the tanks, canals or underground also. Environmental pollution, of course, you will dealing with in a separate subject. Now we will go to the case laws. That's better. Whatever I tell you, one or two case laws, they are very, very important. Please follow them. Number one, Dr. Ramdas Singh versus Babulal, 1982. Dr. Ramdas Singh, he was having a clinic, he was running a clinic, but of course, later, by his side, this Babulal, he has got permission actually. He has got permission to start a brick grinding machine. Not a brick kiln, it's a brick grinding machine. So, due to the emanation of the so-called dust was spreading into the vicinity. The patients who are visiting the hospital, their white cloths are turning into pink color due to the dust. So they are afraid. The clinic, actually the patients started, actually they did not visit the hospital because of the nuisance created by the brick grinding. So even though it affected only the clinic, but major public, the general public are affected. Therefore, he brought a suit of public nuisance against Babulal. Allahabad High Court, yes, accepted and ordered the defendant. Actually, they has given an injunction order asking to shift the machine from there. వేరే చోట పెట్టుకోమన్నారు. ఎందుకంటే యాక్చువల్గా ఇది ఒక పేషెంట్ యొక్క వైట్ షర్ట్ పింక్ కలర్లోకి మారినప్పుడు డస్ట్ ఆయన చూసుకుని అప్పుడు క్లీన్ చేసిన తర్వాత ఓ ఇది డేంజర్ అని చెప్పి ఇట్ ఈస్ కాజింగ్ న్యూసెస్ అని చెప్పి వాళ్ళు రావడం జరిగింది. ఆల్రెడీ ఎక్స్ప్లెయిన్ ఇన్ డీటెయిల్ అబౌట్ ద కేస్ ఇన్ అవర్ క్లాస్. సెకండ్, క్యాంప్బెల్ వర్సెస్ పెడ్డింగ్టన్ కార్పొరేషన్, 1911. ఆల్రెడీ ఐ టోల్డ్ యూ ఇన్ దిస్. సో డామ్నమ్ సినే ఇంజూరియాలో మనకు చెప్పాము. సరే వాట్ ఎవర్ ఇట్ వెదర్ ఇట్ కమ్స్ ఇన్ టార్ట్ ఆర్ నాట్ అని చెప్పాము. ఇప్పుడు కూడా మనం తెలుసుకుందాం. సో మిస్సెస్ క్యాంప్బెల్, ఈవిడకు ఒక ఇల్లు ఉంది. షీ వాంటెడ్ యాక్చువల్లీ కింగ్ ఎడ్వర్డ్ II, he died and the funeral procession will pass in front of her house and there is an elevated portion in front of her house. ఆవిడ ఏం చేసిందంటే షీ వాంటెడ్ టు మేక్ మనీ. సో పీపుల్ వాంటెడ్ టు సీ ది లాస్ట్ రైట్స్ ఆర్ funeral procession of the king Edward II. So therefore she arranged some chairs and she asked the people to sit there by paying money. So she wanted to do business with that. But incidentally, the Paddington Corporation, they have erected a pandal. So based on that pandal, so many people stood and it caused obstruction to the vision of the persons for whom this woman has laid chairs. And actually, she filed a case of nuisance as though the people, the municipality, that's the Paddington Corporation, they have constructed a pandal with which so much of nuisance was caused. You know the statutory authority. And also, please remember, here the court has clearly stated that no damages could be done to the plaintiff. She could see the funeral procession right from the house, but she cannot do business in this way. Municipality has got the authority to construct the so-called podium or padding like pandal like that. So it's not definitely a case of nuisance. Actually, she created the nuisance. Third example. Winterbottom versus Lord Derby, actually. So, Winterbottom's actually he has Winterbottom he has actually blocked the public footpath for a personal function. Normally we will be seeing people will be erecting the so-called side walls, and after going there we have to take a circuitous route. Sometimes it so happens that you cannot reach the destination in time. You want to go to the railway station by 5 p.m. By 4:55 you have to cross this side wall, and you have to take a circuitous which may take 10 minutes. By the time if the train goes away, who is going to be held responsible? So definitely you feel annoyed, is it not? Here the plaintiff filed a suit for public nuisance, alleging that he had to take another route. But the court held that you are not able to prove the others, they did not suffer much inconvenience. Therefore, when there is no much convenience, definitely you have to adjust with the same. So this is regarding the public nuisance. So in the next video, we will discuss the private nuisance. Thank you very much.